Assalamualaikum warahmatullahi wabarakatuh. My name is Basyirah Binti Baharuddin and my matric number is 195199. So this is the oral presentation video for MGM 3351 Group 1. In this video, I will be presenting about the legal talks, breach of contract. The case that I've chosen is about AZIZ, HAMID and others against PERAK ROADWAYS Berhad. The case was discussed at the Malaya High Court Ipoh with civil law number 22-162-2002 by Binti H, and the written case was published on 30 October 2006. So, on 17 January 2006, notice of appeal to the judge by the appellant is against the decision of the senior assistant registrar on the Ipoh High Court, where the lawsuit filed by the appellant was dismissed with cause. The reason used to reject the claim of the respondents is that the claim was filed outside the time limit then, and thus it is prohibited by law under Section 6 (1), the Limitation Act 1953. In this appeal, the appellant is referred to as the defendant and the respondents are the plaintiffs. Issues raised and argued by both prudent lawyers is the cause of action of the plaintiffs against the accrued defendant to claim certain damages against the delay in handing over the vacant possession of the building to the plaintiffs, either on the next day of the vacancy should be given, which argued by lawyer for the defendant, or on when the actual date of vacancy is given, which argued by the lawyer for the plaintiffs. The court stated that Section 6 (1) A, the Limitation Act 1953 limits the time to file an action for damages based on a contract 6 years from the date the cause of action accrued. If the cause of action of the plaintiffs in this appeal accrues the next day the dates of vacant possession should be given, the plaintiff's claim for damages is legally prevented because the claim was not filed within a period of 6 years. But if the plaintiff's cause of action only accrues the next day when the actual vacancy submission date is given, the plaintiff's claim for damages is not prevented and can be processed. After examining the facts and circumstances of this case, this court is of opinion that the date when the cause of action accrued is the next day the vacant possession should be given and not on the date when the vacancy is given. Therefore, with argue and respect, this court does not agree with arguments by counsel wise for the plaintiffs that the time limit is calculated from the actual date of vacant possession is given. Time limit or cause of action begins on the date of default occurs. That is the next day from the date when the vacancy should be given, that is within 24 months from the date of the letter of agreement, and that date is the cause of action accrued. In conclusion, the purchaser's claim was started barred under the provisions of Section 6 (1) of the Limitation Act 1953. That's all from me. Thank you.